So really, it's absurd that they took this case, because there's nothing to settle here unless they are just intent on overturning decades of precedent, which could be the case.
Which side are you on? Which side are you on?
Y'all may have heard about this issue at the Supreme Court, Glacier Northwest versus the Teamsters. And, the facts of this case are basically that these Teamsters drive concrete mixing trucks, and they went on strike as they had cement in their truck. And if they had turned the trucks off while the cement was inside, the cement would have hardened inside of the mixer and totally destroyed the truck. And that would have been just a ridiculous amount of damage. But they did not do that. They left the trucks running so that the employer was able to get the cement out. Now, without the labor of the Teamsters, they were not able to deliver the cement. And so some of the cement was ruined over the course, because of the strike. And so Glacier Northwest is attempting to sue the union for damages because of this lost product. Now, before this ridiculous era of conservative, pro-capitalist judiciary, it had already been settled that expiration of goods is not something that employers could sue unions for. Whether we're thinking about a milkman not delivering the milk, and so the milk goes bad. These are cases that have been had before, as I understand it, in the courts. And the courts have said, no, that's legitimate. That's legitimate. And if you really want to make sure that the milk doesn't go bad, you can get scabs, right? And it's not like Glacier Northwest did not know that the strike was happening. So they could have acquired scabs to make sure that the cement didn't go bad and it was able to be delivered and whatever.
Or, of course, sign a fair contract with their own employees as to avoid a strike, because never forget that a strike is indication of management's failure to negotiate.
Exactly. So, the cement did go bad. The cement went bad, and so it was like a couple $10,000 of, damages or something that they're trying to get, I think. But this would really open the door, the Supreme Court taking this case at all, even though the Washington Supreme Court was unanimous. Like, there wasn't a single dissent in the fact that on the Washington Supreme Court, and they all said basically, this is settled law. You can't sue them for damages over this. This is legitimate outcome of a legitimate bargaining tactic. And so, this is what it is, right? It is what it is. And not only was the Supreme Court unanimous in Washington, there were typically a lot of times what will happen, one of the reasons that the Supreme Court will take up a case is because there's a conflict in the district courts, right? So if a federal court in Texas rules one way on a thing, and then a federal court in New York rules a different way, then on a similar issue, then the Supreme Court will take one of these cases to settle the conflict. To say, okay, look, here's who's right, who's wrong, and here's the law. Here's how you are to interpret the law, other federal courts. But there was no conflict in the federal courts. Everybody was under the understanding that this case was rightly decided. There was no conflict at the district level. There was no conflict on the Washington Supreme Court. So really, it's absurd that they took this case, because there's nothing to settle here unless they are just intent on overturning decades of precedent, which could be the case.
Right. Seems to be the indication.
And if they do that, then if they undo this precedent, then that really opens the door up to all manner of other stuff, beyond just the type of stuff that we're talking about. But even just the type of stuff that we're talking about. What if Starbucks baristas go on strike and for 3 days and their milk goes bad? Well, even though this exact situation has been decided on, it might be overturned, and that the Starbucks baristas will have to pay for the product that went bad because they did not give their labor to the company for using a protected tactic in bargaining.
You know, it reminds me of a couple of months ago, if listeners will recall, Warrior Matt Cole tried something along these lines. They tried to get the NLRB to side with them and force the UMWA to pay them millions of dollars, not just for direct cost associated with the strike, but going so far as to argue they should be responsible for lost production.
Right.
I mean, the whole point of a strike is to withhold labor and therefore stop production and therefore hurt the employer in the pocketbook, right? That is a leverage. And what the Supreme Court is looking at doing is stripping that leverage that we have as working people through the collective action of withholding our labor. That is a very scary prospect.
The employer in Glacier, so they want to overturn this, and their attorney, who is interestingly a former Donald Trump Solicitor General, began his argument by comparing the spoilage of a partial day's worth of concrete with federal security guards leaving their post in the middle of a terrorist threat.
Oh, you mean like their people did on January 6th? Oh, okay.
A ferry boat crew abandoning ship in the middle of a river, and steelworkers walking out in the middle of a molten iron pour, risking extensive damage to the factory equipment. These are all totally different things that we're talking about. I mean, okay, look, so here's a compromise that maybe I'll be willing to make. If they began their strike as they were driving, they're like driving the cement trucks down the road towards the building, and they just jump out, and they've all got like beds and stuff on the side of the road, so they're prepared for this. And they jump out, and the truck just happens to, go into the building. Okay, that seems probably
maybe a bit much.
Maybe a bit much. I don't know. Maybe it should be legal. Maybe it shouldn't be. But at least under the current regime, we can understand that would be illegal. Okay, we can understand that you can't just start your strike while you're barreling down the road at 70 miles an hour. Okay? But that's totally different than this situation. These trucks they were continued mixing the cement so that they did not destroy the trucks. We just had 1 day's worth of product that was spoiled, which is legitimate. And so this is a very, very concerning precedent that the Supreme Court could very well take. And, this is something to keep your eye on. This is something to keep your eye on.
Well, and the other thing, another piece of this conversation is how will labor respond?
Right.
How will the labor movement, institutionally, as far as the AFL-CIO, the Teamsters, and others, how are they going to respond to the Supreme Court situation and how the landscape may change? Because we've been down this road before with some other issues. We had the Janus case a few years ago, going after agency fees. So I'm just curious to know, how is organized labor, big labor, quote unquote, how is big labor going to respond to this? Because there has been a tendency, I think, as labor institutionalized, after its heyday, and we've seen this long decline, I think there's been a tendency for big labor to stick within the legal terrain and just try to do the best they can within the process, right? But that process continually gets worse. The legal terrain continually gets worse for us as working people. So, I think leaders of the labor movement have to be really looking at the implications of a case like this and how that may impact strategies and tactics.
Right.
I hope that there are people, higher up in the labor movement than me that are really having those conversations and thinking through that.
They're important conversations to have, and how are we gonna? I don't know.
And how are we as a people going to respond to the fact that we have this Supreme Court, this institution of 9 unelected individuals, in this case, 5-6 individuals, continually stripping rights away from us that have been won historically over the past century and a half.
Right.
We live in a Gilded Age economy, and we have a Supreme Court and others that are trying to, bring our society back to the Gilded Age as well. The legal framework, the constitutional framework. So that's something else I think that we as a labor movement have to be looking at. Is like, yes, this specific Supreme Court case, how it may impact our ability to strike effectively. But what are we going to do about the situation in general, where we have essentially this rogue Supreme Court that is, unaccountable and continually doing damage to our lives and our rights?
You just saw a clip from the Valley Labor Report. We are live every Saturday morning from 9:30 a.m. till 12:30 p.m. And we pride ourselves on keeping all of our content free to everybody so that we can talk to as many working folks as possible. If you support the work that we're doing, you think that it's important, you think that it's good, then consider making a monthly contribution to the project, and you can do that on our website, tvlr.fm.